the appeal, the Queen on the application of DN Rwanda and the Secretary of State for the Home Department.
Now, we've had an application for the making of an anonymity order. I take it, Mr. Tam, there's no objection to that?
No objection from our side.
Very well, then. We order that no one shall publish or reveal the name or address of the appellant who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellant or any member of the family in connection with these proceedings. Mr. Knafler.
My lords and my lady, I appear for the appellant, together with my learned friends, Mr. Gordon Lee and Mr. Yasser Vanderman, and the respondent is represented by my learned friends, Mr. Robin Tam, QC, and Ms. Julie Anderson. So, our case, at its shortest, is that the respondent's decision to deport Mr. N was clearly unlawful, and that it plainly bore on and was relevant to the respondent's subsequent decision to detain him. In fact, it was the foundation of the decision to detain him. And we say that the real issue in the case is whether the statutory scheme prevents Mr. N relying on that in a false imprisonment action, and we say it doesn't. So that's our case at its absolute shortest. Just unpacking it slightly, it rests on three essential points. The first is that the 2004 order was unlawful, see EN Serbia, and seriously so, in breach of primary legislation and EU law. Secondly, because of the way the statutory scheme is constructed, but also as a matter of fact, the order did bear upon, and it was relevant to, the decisions to deport Mr. N and imprison him. Therefore, we say, see Lumber, he was unlawfully imprisoned. And third, we're going to say, had it not been for the order, the respondent would not have imprisoned Mr. N. So we're going to say that the order caused his imprisonment and he's entitled to substantial damages. Again, see Lumber. And we're going to say that the statutory scheme doesn't require a different result. Firstly, because the statutory precondition for detention under Schedule 3 is that there has to be a lawful deportation decision. And we're going to say that an unlawful deportation decision is insufficient. Secondly, excuse me, we're going to say that it's actually not inconsistent with the statutory appeal machinery for a claimant to submit in false imprisonment proceedings that his detention was unlawful because of an unlawful deportation decision. But even if it was, in our submission, it contradicts fundamental principles relating to the liberty of the subject to decide that a statutory scheme implicitly negates a subject's right to argue in a false imprisonment action that he was unlawfully imprisoned by the state at trial. And then finally, we're going to submit that neither the principle of legal certainty nor the desirability of having efficient deportation provisions come remotely close to negating a claimant's fundamental right to assert in a false imprisonment action that in truth he was unlawfully detained. Can
you help me on
yes,
a point that I probably should have found? Where do we find the operative decision to detain, which is the foundation of your claim? I mean, the statement of facts at paragraph 11 refers to the decision to deport, if I could.
Yes.
And then says the respondent decided to detain, but doesn't give any reference.
We've had to do a little bit of digging on that, and I was proposing to go through the facts just in a little bit of detail.
Yes, okay, we'll come to it.
I'll pick that up then if that's acceptable. But we have finally identified the formal decision to detain and the accompanying reasons, which I'm going to be asking the court to look at briefly. So, leaving aside that aspect of the facts, just again by way of introduction, we're going to be submitting that the facts of this particular case are very strong. as the Court of Appeal said below, the unlawful order didn't just bear on Mr. N's detention, it caused it. And this isn't a case of some minor procedural breach of public law that some members of this court were concerned about in Lumber. The 2004 order made some refugees, including Mr. N, deportable as refugees to their country of persecution and detainable, meanwhile, in breach of the law as laid down by Parliament, the law in the 2004 directive, and in breach of our country's international obligations under the Refugee Convention. Now, in support of our legal case, we're going to be relying on 9 fundamental principles of law, which I won't unpack now, but I'll deliver those later on when we get to Draga.
I remember saying in the appellate committee that I have 7 points of law, and one of their lordships rolled his eyes heavenward and said, "Can we settle for 5?"
I think it's going to be apparent that there are 2 or 3 really critical issues, and some of the other ones I'll be able to address, important though we say they are, pretty speedily. So I hope that will satisfy my lords and my lady when we get there. One of the fundamental propositions is Proposition 9. It's probably the most minor one. Administrative convenience has little or no part to play in the legal analysis. Because that's so short, I actually would like to deal with that right now, and then it'll be done, and I won't come back to it. It's simply that the courts have never allowed the state, and never will allow the state, to imprison people without trial unless the state can prove that the imprisonment was lawful, whether or not that will cause the state administrative difficulties. And I just flagged that up at the outset. If one goes to volume 1 of the authorities, tab 10, this is Kawaja, and it's memory stick. There's just 2 passages, memory stick 473, and it's D to E. I'm convinced the Zame reasoning gave insufficient weight to the important, I'd say, fundamental consideration.
Sorry, which page are we on?
Memory stick 473. 473. So it's 109 of the report.
Thank you.
D, I'm convinced the Zame reasoning gave insufficient weight to the important, I'd say, fundamental consideration that we're here concerned with, the scope of judicial review of a power which inevitably infringes the liberty of those subjected to it. This consideration, if it be good, outweighs, in my judgment, any difficulties in the administration of immigration control to which the application of the principle might give rise. And then at 486 on the memory stick, E to G, so it's 122 internally, E to G. My lords, we should, I submit, regard with extreme jealousy any claim by the executive to imprison a citizen without trial, and allow it only if it's clearly justified by the statutory language relied on.
I think this was quoted by Lady Arden in her judgment, isn't it?
Yes. Yes. The fact that in the case we're considering detention is preliminary and incidental to expulsion strengthens rather than weakens the case for a robust exercise of judicial function and safeguarding the citizens' rights. And that reflects Christian Leszczynski 40 years early on. Just for my lords and my ladies' note, it's volume 333, memory stick 1186 at the top of the page. But before I set off on my little journey, I'd like to respond at the outset to a question that's often asked at some stage during appeal, which is, well, what do you say should have happened in this case? And in this case, that's an easy question to answer, which is probably why I want to answer it right now at the start. It's an easy question to answer because of the decision in Draga at first instance, which we say is the right decision. It's a concrete example of a straightforward and, we say, correct application of principle. And Draga at first instance, my lords and my lady, is in volume 2, tab 19. Now, the core reasoning of Mr. Neil Garnham QC, as
Electronic version, please.
It's memory stick 768.
Thank you.
Sorry, my lady, that's where it starts. His core reasoning starts at memory stick 768. Sorry, his core reasoning starts at para 38, which is at memory stick 776. And at para 38, he talks about the tort of false imprisonment, uncontroversially, I think. And then at para 39, he talks about para 2 of Schedule 3, and he discusses that and the fact that the statutory instrument relied upon was subsequently found to be ultra vires. Then he, at paragraph 41, starts his analysis, which is a lengthy analysis necessarily, of a number of relevant authorities. And then at 57, he gets to Lumber at memory stick 783, and he decides that although Lumber didn't completely cover the situation that confronted him and wasn't determinative, it was highly persuasive, and he fastens in particular on paras 66 and 68 of Lord Dyson in Lumber at his para 59. And then the critical bit of his analysis is at paras 62 to 66. And if I can, I ask, please, the court to consider those paragraphs, because they represent our case essentially as it has been since before 2011. So my plan from here on is to go fairly speedily through the statutory scheme, if that's going to be of assistance, as speedily as possible through the facts. And I think there's something the respondent has said about what the tribunal decided that I probably need to spend a little bit of time on, but I'll try and do it as speedily as possible. There is then what did Lumber decide, which the respondent has put in issue, which I feel I probably have to deal with to some extent, but I'll have a look at that, of course. And then get on to what of course, we really want to talk about, which is Draga and why we say Draga was wrongly decided. And then I'll probably also have to say something about Ulla, which the respondent has brought into play. So, the statutory scheme, perhaps if we start at volume 1, tab 1, starting at memory stick 363 for the 1971 Act as it stood at the relevant time. And I draw attention to, at memory stick 364, section 3.5a, person who isn't a British citizen is liable to deportation if the Secretary of State deems his deportation to be public good. And the court might just want to be aware of little b and 6, the provision for court recommendations. Now, as we set out in our written case, a decision by the respondent that a person's deportation is conducive to the public good is a decision that he's required to notify in writing to the person concerned. And at the material time, that notice under section 3.5a was an immigration decision which gave rise to a right of appeal. So the person concerned could appeal the immigration decision, which was the decision under 35A, before a deportation order was made. So for the appeal provision at the relevant time, we turn to volume 1, tab 3, which starts at memory stick 374. And if we turn to memory stick 386, you see the right of appeal as it stood at the relevant time, where an immigration decision is made in respect of a person who may appeal to the tribunal.
Beg your pardon, which page?
This is memory stick 386, my lord. So it's section 82, as it stood at the relevant time, when an immigration decision is made in respect of a person who may appeal to the tribunal. In this part, immigration decision means, that's subsection 2, and then over the page at memory stick 387, little j, a decision to make a deportation order under section 5.1 of the Act. So that's the decision, which is the deportation of the person is conducive to public good under 3.5a. The deportation order is then made under section 5. So if we go back to memory stick 366, which is behind volume 1, tab 1, 366, you get section 5, where a person is under 3.5 or 3.6 liable to deportation, then subject to various matters, the Secretary of State may make a deportation order against him. Then it explains what that is and what it means.
Mr. Knafler, over the weekend I was searching in vain for the authority for what I understood to be the case, namely that the Secretary of State can't go on to make an order for deportation until any appeal against the decision has been finalised.
Yes, that is the case.
Well, where do we find it?
Well, if you need to...
Can I come back to you on that?
Yeah.
If you would, please.
Yes, I mean, that is certainly the case, and I'm sorry it's not in the authorities at the moment. I don't think it's going to be in dispute. And
I'm sure not,
the
but
precise enactment escapes me at the moment, but we will.
Thank you very
supply
much,
it.
Mr. Knafler.
Thank you, Mo. So then you have 5.2, it can be revoked, and then 5.5 brings into effect Schedule 3. So the sort of relationship that my Lord Wilson has just drawn attention to is one of the factors pointed out by the Court of Appeal in Draga, that there is the option to appeal the respondent's decision to deport between the making of the decision to deport and the making of a deportation order. We then come to the detention powers.
We're dealing with the grounds of appeal. We'll come back to that.
I'm so sorry.
Coming to the grounds of appeal.
Yes, the ground. Well, if we look at.
I mean, he could have taken the EN Serbia point if he had thought it a good point, I assume.
Yes, at the time, yes, the grounds of appeal as they were are set out at memory stick 388 and include section 84E. So subject to a proviso, the point that my Lord Carnwath has made is right, and EN Serbia indicated that it would be possible to take a point as to the lawfulness of a statutory instrument in a deport appeal of the kind that we're looking at. All that the Court of Appeal in EN Serbia then went on to say is that it would be more convenient and better for that point to be taken in judicial review proceedings, because then a High Court judge would make an order about the lawfulness of the underlying statutory instrument, which would have wider effect than a decision of a tribunal. But yes, in principle, the point could be taken, I accept, in the statutory appeal, and therefore we don't respectfully agree with what the Court of Appeal said earlier on in this case that it couldn't be done.
Well, I
It
wondered
can.
about that, yes.
You know, it
Well, that's
can.
helpful, thank you.
So then the deportation powers, the detention powers are at memory stick 370. Power 2.1 is the power that arises subsequent to a recommendation for deportation made by a court. We're not concerned with that. 2.3 we are concerned with, when notice has been given to a person in accordance with regulations of a decision to make a deportation order against him. That's the decision under section 3.5a. He may be detained under the authority of the Secretary of State pending the making of a deportation order. And then, little 3, he can be detained when a deportation order is in force. So in para 2.2 and 2.3 cases, there is what we would describe as being a classic public law discretion, whether or not to detain.
The person just moves from 2 to 3.
Yes, as the procedure progresses, that's right. Just for information.
But as far as 2 is concerned, he does have all that's required is he's had a notice.
Yes, and we would say that means a lawful notice.
Well, I mean, in a way that begs the question, doesn't it? I mean, that's the issue we've got to discuss.
Yes, yes.
But it's a notice which, by definition, assumes that he may turn out to be unlawfully detained because he successfully appeals.
I'm sorry, I didn't quite catch
No,
that.
I mean, implicit in the notice is his right to appeal and the
Yes.
possibility, and to raise all these points about legality, and so that it may turn out that his notice was invalid in the sense that it shouldn't have been served. You say that it makes it completely null so as to destroy the basis of the detention.
I frankly completely...
I mean, that's a narrow issue.
Yes, absolutely. I completely accept that. The notice will inform him of his appeal rights. He's able to appeal the decision. And if he raises the unlawfulness of anything underlying that decision-making process, and that's accepted by the tribunal, the process ends there. And we do say, although the respondent has raised a number of issues, that is absolutely the issue in this case, the effect of the deportation appeal machinery on the ability of an appellant to say, in a false imprisonment tort action, I was unlawfully detained for these reasons. Is he prevented from saying that by implication from this? That's the way we would put it. I hope that isn't too tendentious, but is that implicit in the existence of this appeal machinery? And that's absolutely what we want to get to as quickly as we possibly can. But there probably is some matters I have to hack through first before we get to probably what everybody wants me to make submissions about.
But just
if I'm told just to address that, I happily will, of course.
Without jumping ahead, I mean, will you be saying that whatever the public law grounds on which he succeeds in the appeal, he still has a claim for damages for the detention? Well, I'm assuming he can take, forget about the facts of this, assuming he takes a public law point, such as the EN Serbia point, by way of appeal against the deportation and is detained following the notice. Do you say that whatever the nature of the public law error that's found to exist, then he still has his right to damages for detention?
No, and that's quite a tricky issue, but
I'll come to it.
Well, no, I'm happy to summarise it now. The first response possibly has a danger of sounding rather glib, but I think I do have to say it, that it's not every public law error. See lumber, it has to be an error that bears on and relates to the decision to detain, which in the scenario that we're discussing, it almost inevitably would. But that is the first threshold. It has to bear on and be relevant to the decision to detain, and that's unpacked in Kambadzi and then in Lehigh, as meaning directly. So there's that threshold. Then if one digs a little deeper into the cases, the qualification is not just this concept of direct relevance. There's a very interesting and useful decision of Mr. Michael Fordham QC in Lausicus, where he draws attention to something which is implicit in Lumber, I think, which is that when consideration is given to an anterior decision and the lawfulness of that, the public law error has to be material. It has to be a decision that could have realistically made a difference. So that's another qualification that I'll come to and sort of expand on. So those then would be the foundation for a claim that a person had been lawfully imprisoned. That's not to say that the person would then qualify for damages. There's another hurdle to get over for that, as the court's obviously well aware. And we say, without wanting to spend too long on this, because if it distracts the court, but we say that reflects really what one can discern as being a policy in Lumber, namely of having a pretty high standard for assessing whether or not a period of imprisonment was unlawful, but then also a policy that makes it significantly harder to get substantial damages for that.
Well, we'll come back to that.
Yeah, so right. So the legislation, as this court knows, makes the detailed operation of immigration control a matter for the respondent, which the respondent sets out in immigration rules under section 3.2. The relevant immigration rule is Rule 380. It's not found its way into the authorities bundle, but it's attached to our written case at memory stick 380. No, that's not right. It's memory stick 79. And this says that a deportation order will not be made against any person if his removal in pursuance of the order would be contrary to the UK's obligations under the Refugee Convention. Then we just draw attention to, at volume 1, tab 8, the bit of the Refugee Convention that's referred to here, which is at memory stick 413. So it's volume 1, tab 8, memory stick 413. 33.1 is the prohibition against refoulement, and then 33.2, the benefit, that benefit may not be claimed by a refugee where there are reasonable grounds for regarding, whom there are reasonable grounds for regarding as a danger to the security of the country in which he is, or who, having been convicted by a final judgment of a particularly serious crime, constitutes a danger to the community of that country. So leaving aside security risks, there are then two factors that need to be satisfied: particularly serious crime and also constituting a danger to the community of the country. And as you'll know, this doesn't strip a person of refugee status. They're still a refugee. And the extraordinary thing about 33.2 is that it enables someone who is still considered to be a refugee to be sent back to their country of persecution, which is why there is a relatively high threshold for doing that. So now the council directive in the bundle is the 2011 directive. I'm sorry about that. That's not the directive that was in force at the time. It's in the bundle at volume 1, tab 7. Not only was it not the directive in force at the relevant time, it's not a directive the UK has ever ratified.
Slight problem then.
Yes, a slight problem. Well, actually not, as we'll see. You've got a supplementary bundle of authorities, and tab 1, or you should have, tab 1 is the 2004 Qualification Directive. And as it happens,
Where would I have this?
tab 1 of the...
I don't think I've got that. Oh, here it is. Black thing.
Yes, yes.
Have you sent that in electronically?
No, these are not, have not been provided electronically. As far as we know, there is no method of doing that.
Oh, there is entirely a
There
method of
is.
doing it.
Well,
Yes,
I'm so
there
sorry,
is
we
indeed.
didn't know that.
It should be well known to one of your juniors, but nevertheless. Tab 1.
So, yes. So as it happens, actually, Article 21 of the 2004 order is in materially the same terms as Article 21 of the... Sorry, Article 21 of the 2004 directive is in materially the same terms as Article 21 of the 2011 directive. So it's Article 21 which reflects Article 33 of the Refugee Convention, and it's Article 21 of the 2004 order, which of course the Court of Appeal in EN Serbia correctly addressed as being the relevant
Which provision are you
directive.
referring us to?
It's Article 21, my lord.
So this one was ratified by the UK, was it?
It was ratified, and despite the UK's non-ratification of the 2011 directive, it remains binding
I see.
for us
Yes, I see.
for the time, at the moment. So, moving on, we come to at Volume 1, Tab 3, starting at Memory Stick 374, we come to the primary legislation, which sets out what crimes are to be regarded as particularly serious crimes, and we find the legislation as it was at the relevant time at Memory Stick 383. And Section 72 defines serious criminal. It says the section applies for the purposes of the construction and application of Article 32.
So, I mean, we've got a number of these sections duplicated, haven't we? I was looking at 377. You're looking at 383.
Yes.
Are they the same or are they different in some way?
What we've done, and this is flagged up in the index, but perhaps not clearly enough, what we've done is we've provided the current versions and the versions at the material time.
I see.
And so from...
What are we looking at 383?
At 383, we're looking at the version as it stood at the material time.
Thank you.
So 72.1 says what it says.
Could I ask a question about 72.1, Mr.
Yeah,
Knafler?
of course.
We know what the Refugee Convention says, and it appears to be agreed on both sides in this case that there could be a deportation of a refugee, as it were, outside these presumptions, to which I say to myself, well, looking at subsection 1, this section applies for the purpose of the construction and application of Article 33.2 of the Refugee Convention. In other words, Parliament might be thought to be saying, this is how we will deal with it, as follows. But it does appear to be agreed, doesn't it,
Yes.
on both sides, that the Secretary of State could step out of Section 72 and look independently at whether, in the light of the Refugee Convention, deportation was acceptable.
I don't think we've conceded.
You haven't
that.
conceded that?
No.
Well, then I misunderstood.
I'm not sure I would without very careful thought, because you have paragraph 380 of the immigration rules that we've looked at, which says that the Secretary of State shall not make a deportation order, except, paraphrasing it, where Article 33.2 of the Refugee Convention applies, and then one has, as part of the overall scheme, Section 72 defining how Article 33.2 of the Refugee Convention applies.
Well, that
And
was what I
think
was
in my
putting to you.
submission, there's no way out of that.
Out of it.
Secretary
Well,
of
then,
State.
in due course, we must hear what perhaps I've misunderstood what
Yes.
Mr. Tam is saying. But
I
in due
hope
course,
so.
not now.
Yes.
We must ask him about that. Thank you, Mr. Natler.
So we have the three routes whereby 33.2 may be satisfied under this legislation. 33.2, which is not relevant to this case. 33.3, which is also not relevant, and then 33.4, which is relevant. Then
You say that the only route to deportation of this refugee was Section 72.4,
yes,
the presumption that arises from conviction of an offence specified in the order.
yes, we do very firmly, if I may say so.
Oh, well.
And then one has subsection 6 about the presumption that the person constitutes a danger to the community. And then I'll come back to subsections 9 and 10. I just flag up here that these prescribe how a tribunal has to approach this question on a statutory appeal. I'll come back to that when we look at what the tribunal in this case actually did. So the 2004 order is at tab 4, starting at memory stick 390, and memory stick 391 contains Article 2, which specifies the various offences for the purposes of Section 72.4a. And then at 392, you see, and these aren't numbered, that one of the specified offences is the offence under Section 25.1a, facilitating the breach of immigration law by a person who's not a citizen of the European Union. And then there's 25A, which is not relevant to us because what Mr. N did was not for gain. And I'll show you Section 25, of course. If one just casts one eye down the page and looks at the next offence, which is aimed at people who stockpile biological agents for aggressive purposes. I mean, that obviously does look like a particularly serious crime. Section 25.1a is in a different category. And if we go back to volume 1, tab 1, and memory stick 368, you do see the relevant offence here, section 25. A person commits an offence if he A, does an act which facilitates the commission of a breach of immigration law by an individual who is not citizens of the EU, and knows or has reasonable cause for believing that the act facilitates the commission of a breach, and then C. And then you see at subsection 6 that you can be liable up for a term not exceeding 14 years to a fine or both, or summary conviction to a term not exceeding 6 months, and so forth. So section 25 obviously contemplates quite a range of seriousness, even in cases where the offence isn't for gain. Then just to complete the picture, volume 2, tab 18, I imagine that, my lords and my lady, this is memory stick 723, my lady, Ian Serbia. I imagine that my lords and my lady may have had some opportunity of looking at Ian Serbia, the case that concluded that the 2004 order was unlawful because it was ultra vires section 72. And just in case, the critical paragraphs are 81, which is at memory stick 756, just the top of a few sentences of 81. And then it's paragraphs 82 and 83. That's the core of the Court of Appeal's reasoning. Essentially, that the order contains reference to offences or offences within a spectrum of offences that couldn't reasonably or rationally be regarded as giving rise to a statutory presumption. So it would follow, although the court doesn't actually spell this out, I don't think, but it would follow that the order also would have to be incompatible with Article 21 of the directive. So, I'll turn to the facts, if I may, and the connection between the order and the decision to deport, and then the connection between the order and the decision to deport and the decision to detain. And what I hope to do is demonstrate two things to the court's satisfaction. The first thing that I hope to show is that Mr. N never was deportable because he never committed a particularly serious crime. And I hope to show that, as I think the Court of Appeal accepted in this case, that the respondent made him subject to deportation and detention because of the 2004 order. And the second thing I hope to do is dwell upon the distinction that you find in the respondent's written case and elsewhere between decisions about detention and earlier decisions, and they repeatedly draw that distinction. And I accept that that's a useful analytical tool, and it produces results that are correct as far as they go, because it is a simple fact that in some cases there is only in front of the court a decision about detention. That's just a fact of life. And in other cases before the court, there is said to be a public law error in an earlier decision. So the tool is absolutely fine as far as it goes. But the fact that there is a public law error in an earlier decision doesn't mean that the public law error, that public law error in the earlier decision becomes irrelevant to the later decision to detain. It might or might not be, but it's often the case that a public law error in an earlier decision doesn't just come into being and die in the past. It often continues to have relevance to a later decision to detain, in the sense that it bears on or even plays a causative role in that decision to detain. And factually, that is actually what happened in this case. So that's one of the things I hope to show. So I'd like to try to...
Mr. Nafler, 2 minutes ago you said Mr. N was never deportable, he never committed a particularly serious crime. Now that relates to my previous question. If we are in the straitjacket of Section 72, and if the only subsection relevant is 4, then are we not looking at what subsection 4 says, namely a presumption if he is convicted of an offence specified by order of Secretary of State? Were you not jumping outside Section 72(4) when you said he's never actually been convicted of a particularly serious crime? Do you follow me?
Well, the Section 72(4)(a), I think the point being made is that it gives rise to a presumption only, which is rebuttable. So I do follow that, if that's the point that's being made.
But can you actually look at the crime and say, oh, it is particularly serious, or can you only do it through the medium of the order? Only if it is specified in the order can it be a particularly serious crime for that purposes of that subsection. So.
Yes, I certainly didn't intend to jump outside of Section 72(4) by departing from that way of looking at it, which we submit is the right way of looking at it. But I still do want to say that Mr. N wasn't deportable because he never committed a particularly serious crime on the facts, and that's why the presumption in his case simply never arose.
Well, I think you need to focus then on why you say he didn't commit a particularly serious crime.
Yes, I'm going to. I'm just.
I think that's the way to deal with my Lord's question.
Yes. Well, we've dealt with the statutory scheme, I hope. I'm now going to turn to the facts. Well, I flagged up two of the things that I was particularly hoping to demonstrate. Actually, there is a third, which is that Mr. N simply didn't commit a particularly serious crime. And
But we've got
Come to
to, I think, focus on why it is you say, notwithstanding the specified offences giving rise to the presumption, Mr. N did not commit a particularly serious crime, and why the Secretary of State can't rely, and indeed is not bound by, Section 72(4). I think that's your task now.
yes, absolutely. I'll focus on that. I mean, a short answer is, well, the Secretary of State relied on Section 72(4)A at the relevant time because it was a statutory instrument that he had made that was in force. The problem that the Secretary of State now faces is that that order was declared to be wholly unlawful by the Court of Appeal in EN Serbia. There hasn't been any appeal against that.
So you
Binding.
say, if I've understood you correctly, the declaration that the order was unlawful or null removes from the realm of Section 72(4) the offence of assisting an immigration offence or whatever.
Yes, absolutely, and that's one of the points I'm going to be making after I've gone through the legislation and the facts and lumber when we come to Draga. Of course, one of the, and I didn't want to trouble the court with the 9 principles that we rely on, but one of those principles is going to be that the court decision in EN Serbia was retrospective, as court decisions invariably are in every single case. Another submission was going to be that once the statutory instrument was declared to be unlawful, then the law is that it is to be treated as having been void from the start, unless one of those very rare exceptions applies that we all know about and that I'll have to say something about later
But I mean,
on.
but as far as Section 72 is concerned, if the order is declared invalid as it was, then subsection 4 can't have any application because subsection 4 depends on there being an order specifying an offence.
Yes.
I mean, the Secretary of State can't rely on subsection 4 if there isn't a relevant order which brings you within it. Can he? I think that's the point, my Lord.
That is the point that,
Yes.
that I think Lady Black are making. I mean, I wondered whether you were saying, when you say he wasn't convicted of a particularly serious offence, well, I'm doing this in the context of suggesting that the presumption should be rebutted. But
No.
Conway's point is, we don't get to rebuttal because Section 72(4)A is simply not engaged where there's no valid order.
Yes, that's absolutely right. That is what I'm saying. Our case is not simply, though, that Mr. N was unlawfully imprisoned. It's also that the legal error, the 2004 order, was causative, was material and causative. And to make that good, we think we probably have to show that Mr. N actually wasn't deportable and that the order made a difference in his case.
But we'll have to think about that.
Yeah.
Can I ask you a really basic question that goes to that then, please? Can you have a conviction that is of a particularly serious offence for the purposes of Article 33 without featuring in one of the sub-paragraphs of Section 72? Is there any particularly serious offence which we wouldn't see here anyway?
Well, as sort of discussed previously, our position is that through Section 72, Parliament has made it clear that what is a particularly serious offence must be defined, admittedly, through secondary legislation. And either an offence is in the secondary legislation or it is not a particularly serious offence as far as Parliament is concerned. So that's our position.
So putting it another way, you have to establish a particularly serious offence, you have to show that it falls within one of the presumptions in section 72. As a matter of logic, it would be possible to have things which aren't presumed to be, but are self-evidently a particularly serious offence. And that's what I'm just trying to close off now. Your case is you have to get through one of the Secretary of State has to get through one of the hoops in section 72.
Yes, because of section 72(1). But I do see the point that my lady is making.
Well, it may be caught by section 72(2), is it not?
I'm so sorry.
Section 72, subsection 2, person shall be presumed to have been convicted of a particularly serious crime if he's convicted in the United Kingdom and sentenced to a period of imprisonment of at least 2 years.
Yes.
So if someone were convicted of murder, for instance, and sentenced to life imprisonment with a tariff of 15 years, he would come within section 72 too, wouldn't he?
Absolutely.
Yeah.
That would cover that would apply the presumption to a large range of individuals.
So if Mr. N had been sentenced to something in excess of 2 years, he would have been deportable.
He would have been presumed to have been convicted of a final judgment and therefore deportable, yes. In fact, he was sentenced to...
It's because you have to pray and aid section 72, or at least the Secretary of State has to pray and aid section 72(4), and because you say its effect has been nullified by the decision in EN, that it's not open to him to rely on that. Is that right?
That is exactly right, and I'm going to come on to that when when I make submissions about Draga. That is where we're going, and that is...
Well, let's move on to that then.
My Lord wished me to ignore the trawling through which I was going to do fairly speedily, the facts.
Speedy trawl, perhaps.
I still want to know. I do want to know where the operative decision is, and you're going to come to that.
Yeah. Well, let me do a very speedy trawl. It really won't take long, and then I'm conscious of the fact that my lords and my lady don't have the benefit of a High Court decision or a Court of Appeal decision, which have sort of gone through these facts, or indeed the law, in the kind of detail that the court's been asked to.
We have the statement of facts and issues.
Yes, we do. Some of the relevant documents, as my lord has, I think, just indicate, post-date the statement of facts and issues, specifically the one that my lord just referred to. So, right, most of the documents are in Appendix Part 2, and I'll just flag as many of these documents up as I can without asking the court to necessarily look at them. At Appendix Part 2, page 142, and this is Memory Stick 279, the respondent warns Mr. N that he may deport him. And then at Appendix 2, page 144, Memory Stick 281, and also at Memory Stick 283 and 284, the appellant replies, explaining in various different ways that, in his view, he can't be deported because he's a refugee. Then a more important document presents itself at Appendix 2, page 150 to 151, which is Memory Stick 287 to 288. And that's the respondent taking into account the order and making it clear that it's the order that is the basis of the pending decision to deport Mr. N. That's at 287, 288. You then get...
At this stage, he's still in prison on his custodial sentence.
Yes, he is. He
court
is.
Sentence, yeah.
On the 28th of June, he is. One then gets the formal decision on the 2nd of July, and that's Appendix 2, 152, 153, memory stick 289 to 290. That's the formal decision. And the reasons are attached at 154 to 155, memory stick 291. And those reasons, again, make it clear that the order is the foundation of the decision.
This is a decision to make a deportation.
Exactly. Then, on the 3rd of July, there's the confirmation of intention to deport Mr. N in the light of the 2004 order, and that's at page 158 of Appendix 2, and it's memory stick 295. So just pausing here, and I know I've just flagged those up for the court, we say, and we don't think this is disputed, that the decision to make a deportation order was unlawful because it took into account the 2004 order, which was unlawful, and because the order had a material effect on the decision-making. Now, why do we say Mr. N hadn't, in fact, committed a particularly serious crime? There are a few reasons for that, and our understanding is that the case has proceeded throughout on the basis that he didn't, and I'll come to that. But first of all, there are the remarks of the sentencing judge at Appendix 2, page 128, that's memory stick 265, where the judge accepted there was no question of it being a commercial enterprise. You then see at page 137, memory stick 274, that he was sentenced to 12 months for the Section 25 offence. He also got 6 months for something else. And then I draw attention to the sequence of events in the statement of facts and issues, and there's probably no need to turn it up, but it's memory stick 56, and it's paras 29 to 34. And essentially what that part of the statements of facts and issues indicates is that although the respondent pursued Mr. N's deportation on the basis of the 2004 order, after EN Serbia, he ceased to do so. He still tried to deport Mr. N in reliance on another part of the Refugee Convention. He still wanted to remove him, but ultimately he accepted that he couldn't remove him under the cessation provisions either, and then withdrew the proceedings against Mr. N, reinstated his ILR, and reinstated his ILR, his refugee ILR.
I'm sorry to interrupt, but your reference to the judge's remarks that this was not a commercial enterprise harkens back to the question that my Lord Wilson, and my Lady Blyke have raised with you. Is it possible for a particularly serious offence to exist outside the parameters of Section 72? Because if it's not, I'm not sure what the relevance of the remarks of the trial judge have. Why is it relevant that the trial judge said that this wasn't commercially motivated? If your case is that a particularly serious offence only arises if one of the provisions of Section 72 is satisfied, then absent them being satisfied, what the judge says is neither here nor there.
No, if all one is focusing on was Mr. N unlawfully imprisoned, absolutely. If one wants to go on from there and ask whether...
But my question to you is, do you accept that it's possible for a particularly serious offence to be recognised even if Section 72 does not apply?
No, I think I've tried to make this point before. We do say that it's
that's why
self-contained.
I can't understand why you're referring to the remarks.
This is an issue between you, isn't it? I think Mr. Tam will say that you can.
Yeah.
So it is obviously relevant to you to challenge the...
But we are saying that it is a self-contained code.
Yeah.
On your view, it's not relevant to look at what the sentencing judge said, but if it is relevant, then you say you get home on the facts.
Yes, thank you.
Oh, I see. Oh, well, that's... Well, that helps to clarify that.
Thank you.
I mean, you don't make the preliminary or primary submission that what the judge says is at all relevant. But if, in reaction to Mr. Tam's point, or if we give credence to his point, then you say it is relevant.
Yes, that is the best way of putting it. I'm very grateful to my Lord Carnwath. I will try and say something more about the relevance of that, which I've not successfully articulated as yet, later on. But I'll just leave it at that for
Right, let's move on
if I
then.
may, so we can move on. So, did what we say, the unlawful deportation decision, did it bear on and was it relevant to the decision to detain? And the 2 points that we make, one is that decisions to deport inevitably bear on decisions to detain, because that's the way the statutory scheme works. And then that, we say, secondly, that's borne out by the facts. So the legislation, my lords and my lady have seen that in volume 1, tab 1, and it's memory stick 370, para 2.2 and para 2.3. As you can see from para 2.2, a decision by the respondent to instigate the deportation process is the essential precondition for detention under this provision. So that's the first point. Second, we say inevitably the reasons why the respondent instigated the deportation process by serving this notice of intention to deport, the reasons why he did it will inevitably be relevant to the detention decision. In particular, in a section 72.4 case, the reasons why the deportation process is being instigated will bear on and be relevant to the decision to detain, because the deportation process, the deportation decision will be, firstly, this person is liable to deportation for the public good and is liable to detention. Secondly, this is a person who's failed to rebut the presumption that he's committed a particularly serious crime. And thirdly, this is a person who's failed to rebut the presumption in the Secretary of State's mind at this stage that he's a danger to the community. So those factors are not only the gateway or foundation of the decision to detain, they're also relevant to the exercise of the discretion. Every judge that's considered this issue post-Lumber has decided that a deportation issue bears on and is relevant to a decision to detain. And I just flag these up without asking the court to turn them up so we can make some progress. Mr. Garnham, QC and Draga, Volume 2, Tab 19, at Memory Stick 784. Draga in the Court of Appeal, Volume 2, Tab 23, Memory Stick 989, paras 54 to 58. The Court of Appeal in this case, which is Memory Stick 140, Part 1 of the appendix, in fact, Memory Stick 145, and it's paras 1 and 42, as a High Court decision called Lausicus, at Volume 2, 25, starting at Memory Stick 1027, and it's Memory Stick 1045 onwards, in particular paras 38, 53 and 54, and a case called Kamoka, which is Volume 5, Tab 60, and it's at Memory Stick 1938, paras 49 to 55. So there's that legal
you
connection.
say all these cases show that a deportation order does bear on the detention. I mean, that is Lord Dyson's test in
Yes.
Lumber. So you're slightly jumping the gun. What I think you mean is all these judges have decided that the detention wouldn't have taken place in the absence of a deportation order.
Yes, I'm slightly jumping the gun. We'll come to Lumber shortly.
Yes, very well.
But just briefly to look at, I've tried to show that as because of the way Schedule 3 is drafted, inevitably the decision to deport, particularly one under Section 72, will bear on the decision to detain, will be a foundation, to use more neutral language, for the decision to detain. Factually, the detention documents, to answer my Lord Carnworth's question, the authority for detention of the 2nd of July 2019 is to be found at memory stick 336, which is in core volume. It's the supplementary documents right at the very end, and it's at 3. Oh dear. Let's say 336. Sorry.
Found it at the end of Appendix 2.
Thank you.
It's definitely on the memory stick.
No, it's.
What are you looking for, Mr. Naffler?
I have a note that it's memory stick 336.
And what is it that you're looking for?
The formal authority for detention.
Yes,
which
Of
it
the
is.
2nd of July 2007.
the 2nd of July.
336.
Sorry?
336. Electronic.
The other numbering?
Right.
Be electronically present, but not in a hard copy.
What's gone wrong is, that's right, it is electronically present, and I'm being rather antediluvian in looking at the papers. It is physically present, and it's at memory stick 21, well, it's at page 2134 in the supplementary documents at the end of the core volume. No, it's not. It's not. Sorry, that's the letter. No, I think my lord's right.
Yeah.
It's only in the memory stick, and I've come without my memory stick. So it's a memory stick 336.
It's quite a short document. And
It's just a pro forma document.
it'll be printed quite easily.
It's just a pro forma document. The decision maker's reasons, though, are in the core volume supplementary documents at the back of the core volume in the last section. So they start, at memory stick 339. So over the page.
Just pausing on the authority for detention, it simply says that he's decided to make a deportation under Section 5, and then he hereby, in pursuance of paragraph 2.2 of Schedule 3, authorises in his constable, in accordance with him, to cause him to be detained from the date of his release until the deportation is ordered made.
Yes,
So that's clearly made under paragraph 2.2 of Schedule 3,
exactly.
and based, as you say, on the deportation.
And so the decision maker's reasons we've all managed to dig up, starting at memory stick 339, the last section of the core volume. This records the date of the detention as starting on the 3rd of July. At 340, it refers to the fact that Mr. N was granted indefinite leave to remain as a refugee. And if you see under progress since last review, it records that the intention was to apply Article 33.2 to his refugee status. And then the proposal is proposed to maintain detention for him because he's used deception and false documents, which are the indicators, which are the key factors in the crime under Section 25, which triggered the use of the order. And then we've got the case notes, which start at memory stick 2123, and the relevant passages are at 2128.
Sorry, have we looked at 340 yet? MS 340.
Yes, that's what I was referring to and reading out bits of. I'm sorry. So at the top of 340, there is the reference to the fact that
Yes.
he was granted refugee status. Then progress since last review, there's a reference to the intention to apply Article 33.2, and then the proposal to maintain detention because he's got a history of using deception of false documents, and those are the features of the Section 25 offence which triggered the use.
Well, yes, but it says we make it unlikely that any trust can be placed in him to
Yeah.
comply with any conditions of his release. So they're obviously considering, well, maybe he could be allowed out on condition or bail, but we can't trust him, so we're going to detain him.
Yes, I mean, that simply marries up with the point I was
That's a
trying to
perfectly
make.
valid ground, isn't it? If
Oh, yeah, it's just-
if someone's pending an appeal, you can't deport him pending that, but and you consider whether he's going to be trusted. And if they say, no, he isn't, and therefore detained.
Yes, the way that as I was saying before, the way that the order is of relevance is that it leads to the deportation decision, which is the sort of gateway to the ability to make this. But the reasons why the decision to deport was reached because of the 2004 order also come into play factually
everyone,
here.
including your client and his advisors, are proceeding on the basis that the order is valid.
Yeah.
He's going to challenge the decision on various grounds, but not that.
And then when you come to the case notes at 2128 and over the page 2129, you see throughout these case notes reference to the fact that
Sorry, I'm confused by these numbers.
2128,
It's the back
Of
of that.
the, yeah.
this is at the end of the
Oh, I see, sorry.
core volume.
I'm
You've got the case
way
notes
behind.
starting at the
Yes.
top of starting at the top of 2128, 2nd of July. If one goes through these case notes, you see under brief case summary, second para, Mr. Nezza was granted indefinite leave to remain as a refugee. Then under consideration, he was subsequently convicted of criminal offences. Then over the page, I think it's the first, second, third, fourth paragraph down, likelihood of removal within reasonable time. There's reference to Mr. N's refugee status being revoked and him being removed. And then there are entries 2nd of July, 2nd of July, 3rd of July, which all make it clear that Article 33.2 is being applied to Mr. N, obviously through Section 72.
But there again, he's aware of his liability for deportation and would therefore have reason to abscond.
Yes.
So the basis of the detention is the risk of absconding pending his appeal. And it's acknowledged that if he wins his appeal, well then he'll obviously be released.
Yes, but your argument is that the anterior basis is the deportation order.
Yes,
Well, we now know that. Then. Anyway, sorry, I'm jumping ahead.
It's not just the anterior basis either. What I've tried to show, and I tried to flag this up at the start of this section, is that the distinction between earlier decisions and decisions to detain has some use, but it's actually very artificial, because both as a matter of law and in this case as a matter of fact, that earlier decision to deport, based as it was on the 2004 order, continues to be alive, it continues to be relevant, it continues to be operative in the decision to detain. And I completely take by Lord Carnwath's point that a feature of the decision to detain was the Secretary of State's concern that Mr. N would abscond. That said, the foundation for the decision to detain, because of the way Para 2.2 is expressed, the foundation and gateway is the deportation decision, the notice of decision to deport.
In other words, you say if the deportation order was not validly made and therefore remained the basis on which all of these considerations were undertaken, the relevance of the consideration falls away. But
Yeah.
the deportation order is still the means by which, or the route by which, these particular considerations as to whether he's likely to abscond or not have any purchase, have any relevance.
Exactly, and factually you can see that throughout the notes which set out the decision maker's reasons for detention, yes, they do express concerns that Mr. N might abscond, but these notes are shot through with references to the fact that Mr. N is a refugee, but his refugee status, as it's being put here rather erroneously, is being revoked through Article 33.2. And it's the offence that gives rise to the possibility of how they put it, revocation, the offence of flouting immigration control, that is one of the big reasons for deciding that this is the kind of person who ought to be detained. So not just legally because of the way Para 2.2 is structured, but factually, the decision to detain takes into account, and in fact it's shot through with references to
Well, I wonder whether you would put it rather more fundamentally than that. It's not a question of it being shot through. It is dependent upon
completely.
the deportation order and its validity.
Foundation.
It is the absolute foundation of it. Perhaps I don't need to go this far. I am just pointing out that if you look at the factual reasons, it is referred to throughout the decision-making process about detention. It's not just something that happened in the past.
But it's obvious that. I mean, that seems to be completely obvious that the deportation was the basis of the detention.
Exactly. Well, that's our
that's
point.
not-
That's our biggest point.
I don't think that's really the problem.
Just a matter of incidental question. When you say, I think perhaps you're right about this, it's not a question of revoking his refugee status.
No.
It's a question of his refugee status being not overlooked, but discounted if he came
Yes.
within.
Yeah, the reference to revocation is wrong.
Yeah.
In fact, that's the whole point of Article 33.2, the sort of, that's the shock of it. You are refouling somebody who you still accept as a refugee to their country of persecution.
Right.
Right, well, perhaps I'll...
Where are we now?
Well, I really want to crack on. The point being made about the tribunal is that the tribunal reached an independent decision of its own that Mr. N committed a particularly serious crime. I really don't want to spend any more time on the facts, and I'm going to just direct the court respectfully, if I may, to the tribunal decision at Memory Stick 302, and in particular, I think it's paragraphs 19 to 23 and then 31. I'm asking the court not to turn that up now because I really want to crack on to what I think the court really wants me to deal with. If the court looks at those passages, the court will see that the tribunal was very, very far from reaching its own decision about whether a particularly serious crime had been committed and whether Mr. N was a danger to the community. All the tribunal did was decide that the statutory presumptions had not been rebutted. Not only is that clear from the facts, that was the only function that the tribunal had. And I just do make the legal point here. One goes back to section 72, as it then stood, which is in volume 1, tab 3, and it's memory stick 3.8. Starting at 383, you get section 72, and it's at memory stick 384, subsections 9 and 10. If I can just ask the court to look at that. Subsection 9 says that subsection 10 applies where a person appeals under section 82, wholly or partly on the ground that to remove him from or require him to leave the UK would breach the UK's obligations under the Refugee Convention, and the Secretary of State issues a certificate, which happened in this case. Then, subpara 10, the tribunal hearing the appeal must, and it's mandatory, begin substantive deliberation of the appeal by considering the certificate. And if in agreement that presumptions under 2, 3 or 4 apply, etc., must dismiss the appeal. So the tribunal is required to consider the presumptions and to effectively decide the case in the framework of the statutory presumptions and not go off on some frolic of its own, deciding whether or not a particularly serious crime had been committed under the Refugee Convention, in its opinion, looking at the Refugee Convention and all the guidance and case law that applies. And that's clearly, with respect to Secretary of State, what the tribunal did in this case, is do what it was required to do under 9 and 10. Lumber, so what we say about the tribunal decision is factually, it didn't, contrary to the respondent's submission, reach its own conclusion on the critical issues. But even if it did, that wouldn't assist the respondent, because, as the court has already seen, our case fundamentally is that the respondent simply cannot shelter behind the tribunal decision. As a matter of principle, it can't supply the respondent with a lawful justification for an unlawful imprisonment any more than the divisional court cases in Evans and Brockhill, which we'll come to, supplied the governor with a lawful justification for imprisonment. If the court decisions are wrong, they're wrong. So I'm going to crack on to the next preliminary issue, which again I think we have to deal with. It's not really what we'd be wanting to deal with, but the respondent has put in issue what the ratio of lumber is. So I'm going to try to deal with this fairly speedily. And of course we accept that the judgments in Lumber and Kambadzi contain a lot of important and useful pointers, but we do say that the ratio is in judgment of Lord Dyson, which is in volume 2, 21, starting at memory stick 830, and it's at memory stick 859. So we say the critical passage is in para 66, starting right at the bottom of the page. A purported lawful authority to detain may be impugned, and then the rest of that paragraph. And then paragraph 68. And then we also say what's vital is paragraph 95. The corollary, the flip side, which is the exclusion of vindicatory or substantial damages unless this additional criterion is satisfied. And that's why we say that there's a discernible policy in Lumber of having a high test, holding the state pretty strictly to account when it comes to, is there a lawful justification for this imprisonment without trial, but equally making it significantly harder ruling out vindicatory damages and making it significantly harder to obtain substantial damages. And in the real world of litigation, of course, that makes it possible for the respondent in an appropriate case to accept that there was an unlawful imprisonment and to offer nominal damages of £1 at a very early stage. So we've identified a large number of Court of Appeal and High Court cases, 6 Court of Appeal cases, 34 High Court, 6 Court of Appeal cases, 34 High Court cases that take, by agreement or decision of the judge, these passages as being the ratio of Lumber, and there are a number that are in the authorities bundle. I'll just flag them up because I'm going to submit that the dust has now settled and the right approach, at least generally speaking, is now to be found in my Lord Wilson's judgment, which was unanimously agreed to in the case of Lee Hirons, which I'll come to shortly. But the cases in the bundle which accept that these passages form the ratio is Draga in the High Court, Volume 2, Tab 19, paras 59 to 62, Braga in the Court of Appeal, volume 223, paras 57, 58, Lausicus, volume 225, paras 18 to 54, Kamoka, volume 559, paras 50 to 51, and a case called AB, volume 5, tab 60 at 125. But we now draw attention to this court's relatively recent decision in Lee Hirons, which is, again, it's in the supplementary bundle, and it should be in tab 3. And the issue in this case was whether Mr. Lee, if my lords and my lady have it, it's tab 3 in the supplementary bundle. The issue in the case was whether Mr. Lee Hirons' recall to hospital detention was lawful. And there was a concession by the Secretary of State for Justice at 21 that something had gone wrong. And you can see what the concession was at para 21. There hadn't been an adequate and sufficiently timely explanation of the reasons for the recall. Then at 34 to 35, paras 34 to 35, by Lord Wilson, on behalf of the unanimous Supreme Court, set out what the starting point was for consideration of the false imprisonment question by a reference to Lumber and Kambadzi. And I draw attention to all of that. Strictly speaking, my lord doesn't say that these passages are the ratio, but we think that is the overall effect. And then at para 39, my Lord Wilson explains why, on that basis, there wasn't an unlawful imprisonment in this particular case.
In a sense, then, is it fair to say that it was important in this case to take the lowest possible level establishment? Even taking Lord Dyson's formulation.
If that's how the court reads it, then and that may be a tenable and appropriate way of reading it, then we're wrong, obviously, and then one would have to go back to Lumber and Kambadzi and go through all of those judgments and try to work out, from the ground floor, as it were, what the ratio of Lumber and Kambadzi actually was. And I'm trying to avoid doing that at the moment.
What do you understand the difference between you and Mr. Tam is on this point?
Well, Mr. Tam, as I understand it, suggests that there isn't any clear ratio in Lumber, but that the one thing you can get from Lumber, in his view, is that the public law error has to be inherent in the decision to detain itself and can't be found elsewhere. So I don't think
that's a sort of different point, isn't it?
That's a different point. I don't think he commits himself to what the ratio of Lumber is, but we do. And we say, and perhaps I'll just leave it there for the time being, because my lords and my lady are going to decide if ratio has got a Lumber, if Lumber has got a ratio, and what it is. The best assistance, given the time constraints I can give at this stage, is to say, well, look at Lee Hirons. It may be that my lord was simply putting it at its lowest, because that was an appropriate way of dealing with the case. My Lord will probably know, but my submission is, and my suggestion is, that that is actually a fair summary of what the ratio of lumber and Kabadzi
I mean, his
is.
position, as I understand, is it doesn't really matter what the ratio is on its own facts.
Exactly.
This is a different way of dealing with a sort of two-stage or three-stage case.
Yes, but the trouble is, you do need to, if the ratio of lumber is what we say it is then significantly easier to pick apart the submission that my learned friend has made about the necessity for the kind of connection that he says there has to be, which I will now sort of demonstrate in practical terms. So just leaving Lee Hirons there as what we say is a fair summary of what the law is, and if my lords and my lady disagree with that, then one will have to ask oneself, what is the ratio? And I just say this about what is the ratio. I mean, the reason why so many High Court and Court of Appeal cases take Lord Dyson's statements in 66 and 68 as being the ratio is that they are a test that is recognisable to a public lawyer and that they can be applied quite easily once one gets into some of the other formulations.
But I mean, you're entitled to say that's the right test. I mean, the trouble about lumber, with great respect to those involved, was it may not be terribly easy to get a clear ratio. I mean, there was enough to decide the case, but that doesn't necessarily mean that there was one single ratio. So I suspect we're not going to spend time digging around.
I mean, we do say that and I don't want to spend too much time on it, but we do say that Kabadzi has a clearer focus. And if you look at Lord Hope, and I'm just flagging this up at Memory Stick 964, para 42, Lady Hale, Memory Stick 972, para 69, Lord Kerr, Memory Stick 978, 88, one does have the dust beginning to settle and the majority in Kabadzi coalescing around Lord Dyson's formulation. And I suppose that's what led us to then identify in Lee Hirons the dust settling even further and to a consensus emerging. But if we're wrong, no doubt court will tell us about that. But proceeding on the basis that we're right and that Lee Hirons sort of shows where the consensus has got to, I just want to make a few points about lumber before finally getting on to what we really want to talk about. First thing is, we accept that in lumber, this court wasn't directly considering the type of case before the court today, and we accept that this court therefore didn't reach a conclusion in lumber or Kabadzi, one way or the other, which is binding on this court today. So we do accept that. But second, that said, the ordinary meaning of the words used in lumber and Kabadzi as summarised in Lee Hirons does actually cover what happened in this case. Was there a public law error that bore on and was relevant to the decision to detain? Yes, I mean, to put our case at its lowest, the order was material to the decision to deport, which was therefore unlawful, and the decision to deport, obviously we say bore on and were relevant to the decision to detain. They were the foundation for it, as my Lord Kitchen pointed out, and as I think the Court of Appeal accepted. I mean, the respondent goes so far in his written case to say that we're stretching the words of lumber, but we're not. As written, those words obviously cover what occurred in this case, though I'm not suggesting that ties the hands of this court. I'm not suggesting that. But again, that said, if one looks at the formulation in para 68 of lumber, Lord Dyson, it does actually look as though those words were intended to have a wider effect than just in relation to legal errors in prevention decisions themselves. Of course, no one would have intended those words to be applied by rote without careful consideration. But what Lord Dyson doesn't say is that there has to be a breach of public law in the decision to detain. He doesn't say that. his words must have been carefully chosen, and they clearly seem designed. They don't just happen to cover wider forms of error. They seem intended to encompass a breach of public law that isn't in the decision to detain itself, but is more distant, providing, as he puts it, the relevant connection is there and the breach bears on and is relevant to the decision to detain. So that must have been deliberate, and it must have been designed to embrace public law errors that, on assessment, are truly relevant to the decision to detain, wherever they may be found. What's important is the connection, not where they're found. And as I've tried to show, both legally and factually in this case, the order wasn't something isolated and separate in the past, but was the foundation of everything that happened subsequently. So fourth, what must Lord Dyson and those who agreed with him have had in mind by public law errors outside the detention decision itself? And we would suggest top of the list must be the kind of case before you today where a person has been unlawfully identified as somebody who's deportable when actually they're not. Fifth, and this is a point we make and BID makes as well, and it only goes so far, but I do make it. The context of Lumber was a decision to detain that took into account an unlawful policy. Now, I accept in Lumber, and indeed in Kambadzi, the policy was a policy which set out the criteria and procedures that were relating to detention itself. I mean, of course I accept that. But the fact is, it was a policy that was decided on separately and before the decisions to detain. For obvious reasons, that policy was relevant to the decision to detain and capable of affecting it, although actually it didn't in the view of this court. So Lumber does contemplate a public law error that is in an earlier and separate decision. And then one comes to the notion of a direct connection, which my Lord Wilson, drew particular attention to in Lee Hirons, and it comes out of Kambadzi, and it's one of the ways in which something which we would say is present already in Para 68 of Lumber, it's something that's there that's been developed by the court by placing increasing emphasis on it as a further control mechanism. And what does that actually mean? Well, in Lee Hirons, my Lord Wilson was careful to point out that what was unlawful in that case, the delayed provision of reasons, didn't have any bearing on the initial decision to detain or the duration of the detention. We say that's a big clue as to what it means. And it's Lady Hale in Kambadzi who provides the most detailed explanation of what's meant by direct. And I'll take the court to it because it is important. But essentially, what it means in our respectful submission, based on, in particular on the detailed explanation by Lady Hale, is that it's got to be a public error that bears on the decision to detain and not something ancillary like the conditions of detention, the grade of officer who makes decisions, the timing of reasons, where that doesn't actually affect the decision to detain or the duration. And it's Kambadzi, Volume 2, Tab 22, and that starts at memory stick 972. And I flagged up to draw the court's attention to it, para 69 from capital E to G. Lady Hale introduces Lumber and the issue in that case. Then and I suppose this is the critical passage, it's 71 to 73. And then just in case, it's 73, one only has to go down to capital B. And then it's 77 where she reaches her conclusions. So we say that direct in this context means relating to the decision to detain and not some ancillary aspect. And just before moving on from lumber, and perhaps this is time to grapple with part of my learned friend Mr. Tam QC's case, as recently raised by the bench, it would be pretty odd in our submission if the public law error in lumber resulted in an unlawful detention, but the public law error in our case didn't. In lumber, the unlawful policy was said to be capable of affecting the decision to detain, but in fact it didn't affect the decision to detain, although the imprisonment was still unlawful. In this case, the order was, as my Lord Kitchen pointed out, the foundation of the deportation process and the detention decision. So in a very real way, the unlawful decision in this case had a much closer connection to the decision to detain. And that's why Mr. N satisfies the second part of the test in lumber. And we say that it's unreal for the respondent to draw the fine distinctions that he does, seeking to separate out and distance the deportation decision from the detention decision. Because as soon as this order came into force, it was inevitable that some refugees who weren't deportable would be subject to the deportation process and detained, because that's how the process works. Not in every case, but in many cases, the subject of the deportation process is detained so that they don't abscond and so that the risks associated with the reason that there is a deportation decision, in the first place, don't materialise. The whole point of the order is it exposes some refugees to deportation and detention who shouldn't have been so exposed. So, very briefly, very briefly, looking again, I think I've already half answered this question that was put to me by my Lord Carnworth, about what kinds of breaches can be the foundation of a claim for false imprisonment, consequential on lumber, Cambadsy and Lee Hirons. I've sort of set out my stall on the qualifications that lumber introduces, and I've set out my stall on the development of those qualifications in Cambadsy and Hirons, with particular reference to the need for there to be a direct connection. I just draw attention, I just flag it up, because I think this is completely uncontroversial. In Lausicus, which is volume 2, tab 25, and it's memory stick 1065 at para 72, Mr. Fordham, QC, pointed out uncontroversially it was common ground between the Secretary of State and the claimant in that case, and in our submission it's correct, that there'll only be a public law error in an earlier decision if that public law error was material in the usual sense.
Sorry, which paragraph, please?
This is 72, and it's Roman numeral little 3 to little 6 in para 72 of Lausicus.
MS number again, please?
It's 1065.
1065, thank you.
So it's another controlling factor that when one's looking at a public law error in an earlier decision, that has to be material in the usual public law sense. That was common ground in that case, and in my respectful submission, correct. But I'm going to come to really the absolute crux of the judicial concerns, as we understand them, that have been expressed in lumber and probably subsequently. Because
I think it's 72.1, is it?
sorry, I just closed the book on that, I'm so sorry. Fine.
It's the whole series of
it starts off with 72.1,
yeah, but it goes
and then it's
right-
72 little 3. And then you get onto the common ground at little 4, little 5, little
Yes.
6.
Thank you.
Thank you.
I'm grateful.
So the real crux of the judicial concerns arises out of the fact that this court has shown that it's alert to the possible need to deal with cases that might turn up where there's a public law error, but it's really not of a kind that, as a matter of justice, strikes the court as requiring even a finding that the imprisonment was unlawful, let alone a finding that the imprisonment sounds in damages. And in Lumber, perhaps not with Lord Dyson, but with all the other members of the majority, there is some expression that there is a degree of flexibility. And I think, as Lady Hale put it, it's not necessary for us, I think as she put it in Combanzi, it's not necessary for us in this case to say that every single public law error will suffice. So, I mean, there are some reservations clearly there about what might happen as a result of if one simply applied Lord Dyson's approach. And so I'll be probably making more haste with less speed. A pragmatic response is that Lumber is now 9 years old. It doesn't seem it, but it is. And the respondent hasn't drawn attention to a single case that in his view is undeserving and that's succeeded, or any evidence that because of Lumber, the respondent has been plagued with lots of unmeritorious cases that he's had to spend time and money dealing with. Lady Hale, I think I just flagged this up, Lumber, and it's her paragraph 204, made that statement that it's not necessary for us to say that every unlawful public law error is relevant, but the error in that particular case was very clear.
In a way, you may be coming to this, but at some point, will you be saying where you draw the line?
Yes, I'm literally doing that now, but
I mean, let me just take an obvious example.
Yeah.
Deportation order made, detention, order appealed against on grounds under Article 8 of the Convention, family life in this country.
Yeah.
And the tribunal decide, yes, there is a strong family life in this country, not appropriate to deport. Does that make the decision unlawful and found a claim for damages?
No, because of the passage from Lausicus that we looked at. So that, as I understand the question, the hypothesis is that the Secretary of State makes a decision to deport that ignores a relevant consideration. For example,
not that it ignores it. I mean, he obviously takes a view on it.
Oh, okay.
But the tribunal say, well, I mean, either he ignores it altogether or he fails to give it adequate weight, or the tribunal say, well, we think there was a valid Article 8 defence.
Well,
and it's clearly material to the detention because it's the deportation, as you say, is basic to the detention. So it's material, but does it make the whole thing invalid?
Well, can I separate that into two scenarios? There's one scenario where the Secretary of State does take into account family life or the conditions in, let's say, Syria and what might happen to the prospective deportee in Syria, but the tribunal takes a different view. There's just no error of law there at all. That's the tribunal doing its appellate job, deciding the case on its facts. Let's take the other type of decision where, perhaps rather surprisingly, the Secretary of State actually ignores a relevant consideration, which on a conventional public law analysis means that that decision is unlawful. He completely ignores the existence of the family life. That will inevitably come out in the wash in the tribunal. The tribunal will look at it and they'll make a decision on the facts one way or the other. Suppose the tribunal decides that family life issue doesn't preclude deportation. In that scenario, the error of law in the Secretary of State's decision to deport will not be material. See Lausicus.
But he's not he wins, so that's fine.
No, but it won't be a material error, so it simply won't be capable of being brought into the equation as a public law error that is capable of bearing on and being relevant to the decision to detain. So that just goes completely out of the window on that analysis, and that's the importance of the extra Lausicus safeguard. If I can, I'll just pull back and try to, because what we say is that...
I mean, you're saying in that sort of situation,
yeah,
if the Secretary of State has considered the Article 8 issue, but reached a different view on it to the tribunal, then there's no illegality, no claim.
no question.
If, on the other hand, you can show that the Secretary of State's failed to consider it at all, then there is an illegality and you have your damages claim. Is that right?
Well, if he's not considered it at all, potentially there's an error of law, but will it be a material error of law?
Well, if he hasn't considered it at all, and if he had considered it, he would have recognised that it was an Article 8 claim, a valid Article 8
Then
claim.
it would be
it would be an error of law.
Yeah, but if...
Unless it can be shown that his failure to consider led him to a decision which was insupportable, then it won't.
Exactly, and if the tribunal decides that actually those Article 8 considerations that the Secretary of State failed to take into account don't carry the day, the Secretary of State will easily persuade anybody who asks that his failure to take them into account earlier wasn't material. So any false imprisonment claim simply wouldn't get to full space. There wouldn't be a public law error, a material public law error in that earlier decision. See Lausicus. But if I may, what I'll do is I'll just step back a little bit, because the concern that judges in this court have had is very different from the concern articulated by my learned friend Mr. Tamkisi on behalf of the Secretary of State. The concern, and this is borne out by what the dissenters in Lumber have said, the concern, and also by the reservations expressed by some members of the majority, the concern in this court has not been about the type of connection between the public law error and the detention. Everyone seems to be happy with Lord Dyson's formulation that it's got to bear on and be relevant to, and that's been sharpened up in Cambadsy and Lee Hiron's by reference to the notion of directly bearing on and directly be relevant to. Nobody judicially seems to be worried about that. What the concern is that there may arise a case where someone bases their claim for false imprisonment on a public law error that's very small, that may be to do with process.
I don't think that is the concern. The concern is to find a sort of principled basis for distinguishing between the cases which are court. I'm really thinking of, you'll come to Drago and Lord Justice Sullivan's judgment at paragraphs 59 and 60, where he deals with this question of where you draw the line. But let's come to that in due course.
Let's come to that in due course. I just sort of leave this issue by sort of returning to the point I was making earlier, that if there is a concern, and I may be wrong, if there is a concern that unduly small breaches of law may found successful claims in false imprisonment when really that doesn't seem right, I just sort of draw attention to the very fundamental error of law in Mr. N's case. This wasn't a flaw in procedural decision-making. This wasn't failing to take into account some somewhat material factor. This was a statutory instrument that made Mr. N deportable in breach of an Act of Parliament, an EU directive, and the Refugee Convention. It categorised him incorrectly. It goes to the absolute foundation of the whole process. So it is as serious as it gets. And I just make this point before perhaps sitting down, that an error this serious would have satisfied the dissenters in Lumber. Just to flag up, Lord Brown, Volume 2, tab 21, and it's paras 182, 193, would have accepted that a breach like this was sufficient, one that identifies somebody as being liable to deportation when they, sorry, Lord Brown and Lord Rogers, sorry, I should have said it's memory stick 943, it's para 357. They would have accepted Mr. N as succeeding because the public law error in his case was an ultra vires SI that exposed him to deportation and detention when he was liable. Lord Phillips thought that the legal flaws in the process were immaterial because they weren't causative, because the appellants would have been detained in any event. So Lord Phillips, we suggest, would have accepted Mr. N's claim because the error in this case was causative. Lord Walker is more difficult to assess because his view that then was that there needed to be a serious abuse, and it's not, or, which includes misfeasance. There's no other explanation, and it's difficult to work out precisely what he meant. But if he meant that there had to be a relatively serious breach of public law, then he also would have found for Mr. N because of the serious breach in this particular case. And when we come on after lunch to look at the types of public law acts that in principle really must be quashed and treated as unlawful from the start, unless there's some very powerful reason why not, an unlawful statutory instrument is top of that list. And this is the type of statutory instrument which, as I say, reached what an Act of Parliament required, what the directive required, and what the Refugee Convention required should be at the very, very top of that list. And so I've spent the morning really making submissions about things that probably we didn't want to make submissions about, and possibly the court didn't particularly want to hear about, but which we felt was necessary to address because of the way the case has been presented. At 2 o'clock, with my lord's and my lady's permission, I will then address as speedily as I can, and I'm not going to address Allah till right at the end if time is permitting. Nothing is going to stop us then, apart from my lord's and my lady, addressing why we say Draga is wrong in the light of fundamental principles.
Right. That's a good point at which to rise. We'll sit again at 2 o'clock.